Greetings from Toledo. I want to talk today about graphic designs that are included in trademarks. Many companies that are going to introduce a trademark have a trademark consisting of two components, a word mark and some kind of graphic design or logo. That means actually those companies have three trademarks. They have the words by themselves, they have the logo by itself, and they have the combination of the two as they are presented by the company. I counsel my clients to protect with an application, first and foremost, the word portion of a mark. The word portion is how people will remember the company as the source of the product, and the word part of the mark is how satisfied customers will tell their friends about your mark. This isn't to say that the graphic design or the logo isn't significant, but if you want to do your trademark registration economically, focus on the most important part of the trademark, and that is, again, the word portion. Some trademark owners who feel flush will actually apply to register all three trademarks. Again, the words by themselves, the logo by itself, and the combination of the logo with the words. I do work in the United States for trademarks owned by a particular German company, which routinely, uniformly, every time applies for three trademark registrations. We love them. It's a 3-for-1. There is an alternative to applying to register your logo as a trademark, and that would be the copyright registration system. Logos are, under the Copyright Act, works of art. Copyright in those works of art can be registered in the Copyright Office for a pittance. The Copyright Office charges a filing fee of $35 for applications filed through its electronic application system. The term of protection for copyright in a work of art that is owned by a company is 95 years. There are no renewals required. The protection afforded by the Copyright Act is wow. We have an example going back to the time when the Recording Industry Association of America got upset with people downloading music. The association wound up suing people who downloaded music. There was a case out of Minnesota where grandma thought that her grandchildren had used her computer to download music. The association brought a lawsuit alleging infringement of 7 copyrights and sought the maximum damages, and grandma wound up with a judgment against her for $9 million. So far, the Recording Industry Association of America hasn't collected on that, but the case did send a message. Well, I think it sent 2 messages. Don't infringe copyrights, and the Recording Industry Association of America is kind of a jerky company. The association stopped suing people for downloading music some time ago. The example illustrates how powerful copyright protection is. There is an opportunity for a copyright owner whose copyright is being infringed to get a big judgment against the infringer. And again, the cost of registering these intellectual property in the Copyright Office is very small. It would save you the cost of a separate application to register the logo as a trademark. It would also make it unnecessary to register the combination of the word portion of the mark together with the logo portion of the mark. There's another aspect to logos that are developed and used by companies as trademarks, and we've talked about the idea of maintaining your trademark registration by filing renewals at the appropriate intervals. But an application for renewal includes the statement that the owner of the registration is using the registered mark. If the registered mark is a combination of words and a logo, and the owner of the trademark decided to freshen up the logo by adopting a different one, a trademark registration of the words in combination with the logo winds up being for a mark that is no longer in use, and that registration cannot be maintained. You really want to give serious thought to using the copyright side of intellectual property protection to protect those logos. Now, there's one more thing that is very important with regard to logos that are used as trademarks. Very often, a company will hire the services of a graphic design company or a graphic designer to create a logo. There's nothing wrong with that, but there's a trap. And the trap is that copyright protection in a logo arises automatically without any other action required when the logo is created. If the logo is created by a design firm, the logo is protected by copyright before it's delivered to the client. And the copyright is owned by the design firm unless there's a different agreement between the company and the design firm. The copyright in a logo can be assigned or transferred to the company that hires the graphic design agency, either before the work is done or after the work is done. There's another trap that people have fallen into, and that has to do with what's known as work made for hire. And in certain cases, a work made for hire winds up with the copyright being owned by the party that hires the graphic designer. That doesn't apply to any situation that I've encountered where a company hired a graphic design firm. The transfer needs to be made by an assignment. And if it's not made, it's improper for the company to apply to register a copyright claim in its own name. The company has hired someone to prepare this logo, but the doctrine of work made for hire by itself will not put ownership of copyright in the hiring company. That's my tip: how to save money and protect your logo outside of the trademark system. Oh, one more thing. Remember, you'll do better in Toledo.